Let's talk board resignations. While I was at the UNC, one of the many statements that did not sit well with me would have been one of our deputy political leaders, now a minister, saying, you see all them people who wouldn't even make a statement to help us, all their fancy position, they wouldn't even make a statement, but they're supposed to be UNC members. When we get into office, I don't care who it is. It didn't matter to me their qualifications. Those who stood by us, them getting board position. I want to hear nothing about it because their loyalty will be rewarded.
Legal argument. The call for Annette Wattie's resignation from PLIPDECO by the UNC is wrong and in breach of the Companies Act. Background. The United National Congress, UNC, has called for Annette Wattie's resignation from her position at PLIPDECO, a state-owned company. To determine whether such a call is legally valid or in breach of the Companies Act, Trinidad and Tobago, Chap 81:01, it is necessary to examine the statutory framework governing the appointment and removal of directors or officers in state companies, as well as the principles of corporate governance and due process. 1. Statutory Framework. Companies Act, Chap 81:01. The Companies Act governs the internal management of companies, including the appointment and removal of officers and directors. The Act provides clear procedures for such actions, emphasizing the primacy of the company's internal governance structures, i.e., the board of directors and shareholders, over external political interference. Key provisions from the Companies Act. Section 76(1). Subject to the articles or bylaws of a company, directors of a company may be removed by ordinary resolution at a special meeting called for the purpose. Section 76(2). A vacancy created by the removal of a director may be filled at the meeting at which the director is removed or, if not so filled, may be filled as a casual vacancy in accordance with the articles or bylaws. Section 99. The business and affairs of a company shall be managed by a board of directors. Section 242(2)(b). A complainant may apply to the court for an order to restrain oppressive or unfairly prejudicial conduct, or conduct that unfairly disregards the interests of any shareholder, director, or officer. 2. Due process for removal or resignation. The Act and common law make clear that only the board or shareholders can lawfully call for the removal of a director or officer, and this must be done via a properly convened meeting and resolution, subject to the company's articles and bylaws. Political parties or external entities have no statutory authority to demand or effect the resignation or removal of a company officer or director. Any such attempt is ultra vires, beyond legal power or authority, and void. A director, company secretary, manager, or any other officer of the company shall not have the power to convene a general meeting on his own. In order to be a valid meeting, the notice of the meeting should be given by a person duly authorized by the board.
Doubles and coffee, but like them PNM, they holding on, boy. Miss Wattie from PLIPDECO, she called the meeting. 2 people who she claims that the board wants to discipline and so on. She called a meeting even though PNM lost since April 28. She says she ain't going nowhere, she moving ahead. 2 law firms tell her, listen, Miss Lady, you have no local standard, you have no authority, you are a board without power. What are you doing? Our clients are not presenting themselves to you. They will present themselves to the new board if any reason is found so to do.
3. Breach of the Act, political interference and oppression. A political party's public call for the resignation of a company officer, without following the procedures set out in the Companies Act and the company's own governance documents, constitutes a breach of Section 99, undermining the authority of the board to manage the company's affairs. A breach of Section 76, circumventing the required process for removal by ordinary resolution at a special meeting. Potential oppression under Section 242(2) 2B. If such actions unfairly disregard the interests or rights of the officer or other stakeholders, they may be considered oppressive or unfairly prejudicial, giving rise to a right to apply for court intervention. For supporting case law. In Clive Pierre v. Sonatank Limited, the court emphasized the necessity of following proper procedures under the Companies Act and the Company's articles for the removal or appointment of officers. Unilateral or unauthorized actions, including those taken without the knowledge or consent of the board or shareholders, were declared null and void. 5. Conclusion and legal position. The UNC's call for Annette Wattie's resignation from PLIPDECO, if not made through the proper statutory process, i.e., a board or shareholder resolution in accordance with the Companies Act and the company's bylaws, is legally invalid and in breach of the Companies Act, Chap 81:01. Such a call usurps the authority of the board and shareholders, violates the principles of due process, and may constitute oppressive conduct under Section 242, 2B of the Act. Verbatim law cited. Subject to the articles or bylaws of a company, directors of a company may be removed by ordinary resolution at a special meeting called for the purpose. Section 76(1), Companies Act, Chap 81:01. The business and affairs of a company shall be managed by a board of directors. Section 99, Companies Act, Chap 81:01. A complainant may apply to the court for an order to restrain oppressive or unfairly prejudicial conduct, or conduct that unfairly disregards the interests of any shareholder, director, or officer. Section 242, 2B, Companies Act, Chap 81:01. In summary, only the board or shareholders of PLIPDECO, following the Companies Act and the company's bylaws, can lawfully call for or effect the resignation or removal of Annette Wattie. Any external or political demand for her resignation is in breach of the Act and is legally unenforceable.
And if you look in the papers, you will see reference to PLIPDECO. Now, PLIPDECO is a company that's listed on the Trinidad and Tobago Stock Exchange. So it's governed by the rules of the stock exchange. And the directors of a company like that, Angostura is similar, National Flour Mills is similar, FCB is similar. All of these companies, the directors of these companies have a fiduciary duty to serve the interests of the organization rather than their own interests. To change the board of PLIPDECO, you have to have a meeting, a special meeting of shareholders. So Corporation Sole, which is the person who has taken my position, Corporation Sole has to convene a meeting of shareholders because Corporation Sole, which is the Minister of Finance, owns 51% of PLIPDECO. The other 49% owned by various entities and is trading on the stock exchange as well. So there's a process. And if the directors just resign en masse, PLIPDECO, a listed company, would be in breach of the Securities and Exchange Commission Act. So it would be irresponsible of the directors of PLIPDECO, which is a limited liability company, so it's governed by the Companies Act and by the Securities and Exchange Commission and the rules of the stock exchange. It would be completely irresponsible of them to just resign just so. If you look at one of the articles in newspaper this morning, you see the chairman of PLIPDECO making the point, the new group of directors has not been proposed. So what you're going to do, tell them just go, and what you now have a listed company on the stock exchange with no board? That's why I call them amateurs. There's no problem. As soon as the shareholder comes and says, look, I want all of you all to leave, convenes a special meeting, passes a resolution to replace the current directors with new directors, that's the end of it. It's simple.
The PS was transferred, 2 PSs to the office of the Prime Minister, so punitive action was taken without apparent due process.
So, if I may just tee it up a little bit further for the leader of the opposition, we have been in serious reflection on this general issue. The scandalizing of board members in public companies where you face sanction under stock exchange and securities and exchange laws for improper action. Just to remind you that corporations sold their 44 wholly owned companies. It's listed on the Ministry of Finance website. You can see it. 44 wholly owned companies. You can bring a cabinet note today and replace everybody, because he who appoints can disappoint in those kinds of ways. But to step out into the public domain and scandalize people, carrying articles, for instance, by a former Attorney General as a legal representative for people saying, I'm not listening to you because you should change and you don't have the government's mandate, that ought to be known to be in conflict with the law. Section 99 of the Companies Act is very clear as to fiduciary responsibility and liability, particularly when this government in a previous incarnation sued people, a vast number of people, for breach of fiduciary obligations, and then those cases fell apart. But on the issue that we were just speaking about, which is of concern, and this is persons who are being scandalized, not only public servants, I want to mark the spot that there are a number of employees of companies who are being targeted as well.
Doubles and coffee, but like them PNM, they holding on, boy. They Miss Wattie from PLIPDECO, she called the meeting. 2 people who she claims that the board wants to discipline and so on. She called a meeting even though PNM lost since April 28. She says she ain't going nowhere, she moving ahead. 2 law firms tell her, listen, Miss Lady, you have no local standard, you have no authority, you are a board without power. What are you doing? Our clients are not presenting themselves to you. They will present themselves to the new board if any reason is found so to do.
Anil Roberts calls on social media for Annette Wattie to resign from her position as chairman of PLIPDECO can be characterized as a form of public bullying. Bullying, especially in the digital age, extends beyond the schoolyard and is now recognized as a persistent problem in adult and public life, often manifesting through repeated, targeted, and public attacks or pressure on individuals via social media platforms. When a public figure uses their platform to repeatedly question someone's legitimacy, demand their resignation, and frame their continued presence as shameful or illegitimate, it creates an environment of sustained public pressure and humiliation that aligns with the modern understanding of bullying. Roberts' statements, such as Wattie has no legitimacy whatsoever. Her government lost. She is a political appointee, the PNM is gone, therefore she must go, are not simply expressions of political disagreement but are direct, personal attacks that single out Wattie and pressure her to act against her own judgment and possibly against proper legal procedure. This kind of rhetoric, amplified through social media, can have significant personal and professional consequences for the individual targeted and is designed to rally public opinion against them in a way that goes beyond reasonable political discourse. Notably, while this public campaign against Wattie has been very visible, there has been a conspicuous silence from the unions on the matter. Unions, which typically advocate for fair treatment and due process for workers and leaders alike, have not publicly addressed or condemned the nature of the attacks against Wattie. This silence is significant because it suggests a lack of support for her right to due process and protection from public harassment, which unions usually champion in other contexts. In summary, Anil Roberts' social media campaign against Annette Wattie meets the criteria for public bullying, as it involves repeated, targeted, and public pressure intended to force her resignation, rather than relying on appropriate legal or corporate mechanisms. The lack of response from unions further highlights the one-sidedness of the public discourse and leaves Wattie without the usual institutional support that might be expected in such situations.